I'd like to make a mention of item number 3, Your Lordship. If this matter may be taken up after 2 weeks.
Why?
Item number 3, Your Lordship.
This is
Senior counsel is indisposed, Your Lordship.
a long pending matter. If
After 2 weeks, Your Lordship.
it cannot just go on like this. One day senior counsel is not available, next day you will not be available,
Your Lordship.
then the day after that the petitioner will be sick. What do we do?
We may have it after 2 weeks, Your Lordship.
Mr. Learned Counsel, for the petitioner has submitted that has sought for adjournment of this matter on the ground that the senior counsel who is leading the matter is indisposed. The plea not be objected to by the state respondent, by the respondents. Who is appearing with the respondent?
For the state,
Private respondent is supposed to be here. So, Deputy, you are here.
For the union.
This is where that school is not represented.
Yes.
This is the case where the school is not represented.
Yes.
On consideration of the preamble, same not being objected to by the union, by the respondent, Union of India, as well as the state respondent. Accordingly, prayers along. This is matter up to 2 weeks.
Much obliged.
An issue then.
May I please, Your Lordship? Your Lordship, I beg to mention item number 5, 6 and 7. They are connected matters, Your Lordship.
Why?
Your Lordship, I pray that this matter may be come out on Tuesday, Your Lordship.
Cannot be like this. Time and again, judgment is sought and
Your Lordship, here for item number 6, we have received the death certificate as well, Your Lordship. So we will be filing it on Tuesday.
who has died?
Respondent in item number 6, Your Lordship.
I know 6.
Yes, sir.
So what about 5, 7, 8?
Let it come together.
What is the stage of the case?
This evidence. Your
How many witnesses have been examined?
Lordship. 2 witnesses has been examined, Your Lordship.
How many witnesses are there?
Here, I believe, I think so 11 of them.
11.
Yes, maybe 11, Your Lordship.
NDPS matter.
Yes, NDPS matter.
My case, almost 5 witnesses examined. 5, 6.
No, it's all the accused are in the same case or
My one is different.
different?
Here 5, 6 and 7, they are in the same, Your Lordship.
5, 6, 7.
Yes,
Same.
Your Lordship.
You are appearing for?
I'm appearing for respondent.
No. In which number?
8.
8. So 8 is separate.
Separate.
We will take up this matter. One plea made by Ms. Learned Counsel for the respondent seeking M. I have to pass an effective order here as far as this 6 is concerned, since you have some
5, 6 and 7, we are appearing, Your Lordship.
true. But now you are saying that
yes, Your Honor. Yes,
as
Your
far as 6 is concerned,
Item number 6.
have you produced the death certificate?
We have received today, Your Lordship. We will file it on the next date in the form of.
Wait for a while. I'll pass the formal order.
Okay.
Let the matter be called up.
Obliged.
From supplementary list, item number 1.
Lordship is a private respondent. At this stage, notice may be issued to the victim.
Yes, Your Lordship.
Also.
Yes.
Yes. What's
Your Lordship, let the notice be served through IO.
Mr. Khan,
It's already charged.
right, I think we'll take up this issue as far as appearance, reading the complainant.
Lordship is correct.
Of course, the informant has to be read, in terms of 439.
439 is.
1A. That in bail matters.
Very true, Lordship. Bail matter will be different from his, yes.
Bail and appeals are different altogether.
Lordship,
But
the other.
the mode and manner in which
Absolutely.
that has not been spelled out, or I believe you are there in the other case where you have
Yes.
suggested,
And I've given, Lordship, the other day I've given to the bench strength the additional argument.
what I'm trying to say is this, that as far as that matter is concerned, I will not touch on the area of bail. That will be confined only to the the issue involved.
Lordship, we are grateful, yes. Because
As far as bail, because
439 takes care, statutory provision is there.
it'll be confusing.
Yes.
We'll take up this matter only on the issue of the form and format of issuance of the notice.
Absolutely correct, Lordship.
So those guidelines which you have suggested, we'll
Delhi, Bombay High Court, Guwahati,
Delhi,
and the latest one which your Lordship told us and we got it. And I brought to the notice, yes, Guwahati also.
Guwahati and all those things.
And then we'll start to streamline, your Lordship, whether POXO matter or other IPC matters. Lordship is correct, because bail matter 413 is taken care. Let's not make it more murky by saying what is to be done there. We'll go by statutory requirement, but other areas where statutory requirement is silent, and there are 3 high courts which are evolved by principle. So then our Honorable High Court will decide as to what should be done.
You see, because more often than not, the form or the precedent that we follow, in fact, the law that we follow, as far as the issuance of notice is concerned, is the parties will take steps through the regular mode.
That is an official way, yes.
Goes,
yes.
receive, not receive, whatever the case may be.
And then file an affidavit.
Then service report.
Service complete, yes.
So that has to be followed. But there must be a departure as far as these matters are concerned, for which perhaps some guidance from the court may have to come.
Lordship is correct. And what would be the breadth and length of the departure, and what would be the guiding light? That is an area which we need to
whether
follow.
it would infringe
Yes.
on the statutory provision.
Absolutely
as far
correct.
as issuance of notice is concerned.
Absolutely correct. Because of the principle of law coming out from 3 high courts.
So we'll take up this hearing on that as far as this case is concerned.
Any time,
Matter-
Lordship,
matter will be
next
settled once and for all.
next week. Once that order comes in that particular case, Lordship, yes.
Heard
Lordship is correct. I think so. 439, let's not touch it. Absolutely. We're grateful, Lordship, yes.
Heard Ms. Letter Counsel for the petitioner, who has at the outset submitted that notice may be issued upon the respondent number 3, who is the complainant. Yeah, Anna Omni. Heard Ms. Letter Counsel for the petitioner, who has submitted that this is an application for grant of bail in connection with grant of bail
Longpo special box.
on behalf of the accused person himself has filed. Not
his wife,
who is the petitioner?
Balvinder Singh.
Petitioner.
Petitioner, yes, Your Honor.
And what is her? She is not the accused.
Yes,
She is not the accused. And who is the accused person?
Daud Peterson.
Huh?
Daud
No.
Daud
What is his relationship with the?
wife. A husband. The
His
accused is the husband.
Kunung Tongo?
We have to get at 439.
Grant of bail on behalf of the accused husband of the petitioner, who has been implicated in Nongpo Women PS case number 72 under bracket 10 of 2024 under section 2 and legs. Since a bail application under the POXO relating to offences under the POXO Act has been preferred, the letter counsel has submitted that the complainant who had filed the FIR has been read as party respondent herein. Next, since I know next order. Since the state respondent, that is one respondent number 1 and 2, have appeared to the learned PP, the learned counsel has submitted that notice may be allowed to be issued on this respondent 3, public complainant. Next, at this juncture, Mr. K. Khan, learned PP, has submitted that though there is no objection to the arrangement of the complainant in this case as party respondent, however, the mode and manner of issuance of the notice, for which there is no specific format or rule, at present, therefore it is prayed that this court may take up this matter for further consideration to finally devise the appropriate method for issuance of notice upon the said complainant or survivor for that matter, considering the circumstances surrounding a case under the POCSO Act or cases concerning cases involving crime against women.
Lordship is.
Accordingly, on consideration of the submission made by the learned PP, this issue would be taken up for hearing on the next date. Parties are allowed to file any authority as far as this matters, as far as this issue is concerned. So you can do that.
All right.
Place this matter after 2 weeks.
Item number 2.
My lord, this is for cancellation of anticipatory bail. He's threatened. We have received FIR that he has threatened a witness. He has not appeared before the IO even once. So it's not just a case of non-cooperation. It's a case of interfering with the investigation. And further, he has not furnished bonds. He has not submitted his passport as well, my lord. There were specific directions, conditions, page 29. There were 5 conditions, my lord. He is violating 4 of them. The other one was he shall not leave the jurisdiction of India without prior permission. We don't even know. He hasn't deposited the passport. We have served several notices, 91, 41A, even through his counsel, speed post, WhatsApp, but he has not, in fact, before the court of learned JM also, he has not appeared twice for recording of his specimen handwriting. So, my lord, it's a fit case for cancellation of bail.
Court Miss SC, letter G, who has submitted that this application has been filed for cancellation of the bail, anticipatory bail issued by this passed in AB number 16 of 2024. The prayer is made primarily on the ground that the petitioner has failed to comply with certain conditions imposed by this court in the said application, under bracket dispose of. So after the passing of this order in this anticipatory bail application, Was he arrested?
No, my lord, he never appeared. Section 9140. And in fact, if my lord would remember, before the grant of interim bail, we had tried to find his address. He was not there. In Jaipur, the address that they have been providing, he was not there. We were informed that he's in Hyderabad. We could not find his address.
See, because the operation of the conditions would kick in only in the event of his arrest.
My lord, I
First
understand.
you have to arrest him, then he complies with the...
My lord, I understand, but as far as Supreme Court's judgments are concerned, they are clear that if a condition is violated, and if in case he's absconding, my lord, then
Yeah, of course. If you can't arrest him, then that is also one of the ground that you can make out for cancellation. Nevertheless, the principle is logical.
and in fact, in a connected case which was received by Tura Women Police Station, where he is threatened a witness, there he was taken into custody, but he had to be then released on bail. No, Tura Women Police Station, he threatened the witness. That's what IU informed me. Okay, he was arrested in Ampati case, not in Tura. I'm sorry, my mistake. He was arrested in another connected matter, not in connection with this.
So he's in custody now.
He's not in custody. Got
No,
bail, right?
Lordship. He was arrested the one day, and the very next day he was granted bail by the JMFC in Ampati, Lordship.
So now he's at large.
My lord, in Sushila Agarwal, 2025 SCC 1, the Supreme Court has held that it is open to the...
The court will hear the matter on merits.
My lord, even a direction for arrest can be issued.
There is no question of direction, because you can make the arrest at any point of time.
My lord,
There is no bar for you to arrest, because it was as I've said, you see at the outset, it's an anticipatory bail. In anticipation of being arrested, he is granted bail. But that would come into effect only when he is arrested, finally arrested. If he is not arrested, then matter ends there. If the IO feels that he is not required to be arrested, the matter ends there.
I'll satisfy my lord on the next date.
Let notice be issued upon the respondent, the same returnable within 2 weeks. In the meantime, as submitted by the learned GA, the IO or the authorities concerned are at liberty to cause arrest of the respondent in compliance with the order passed in the said AB number 14 of 2024 to 25.
24, my lord.
2024.
Obliged.
From daily list, item number 1.
Your Lordship, now only 4 is remaining, and all 4 is there. There is some rectification.
Your Lordship, since it's substantially been complied with,
So
the matter may be closed with certain observation that the remaining also should be done within the period.
Yes, otherwise it makes no difference. There, you see, what is required is the spirit and the intention.
Your Lordship,
If that is the intention, and they have been working
doing it also.
towards it. So,
Intention is clear.
Your Lordship, this is the instructions.
Mr. Ardana, CGC has submitted that in the ongoing process of compliance with this court's direction, till date
4 individually had to be paid, it is for rectification.
Only 4 is left.
Yes,
4 left.
only 4 left.
Till date, out of the 192 petitioners, only 4 of them are left for the complete compliance of the said order.
Due to some rectification or resubmission.
That doesn't matter. He is not objecting to that. It is prayed that some time may be allowed for the process to be finally.
This matter may be disposed of, Your Lordship.
Mr. P. Nobri, Learned Counsel for the petitioner, in all fairness, has submitted that the intention of the relevant respondent being clear, as has been indicated in the process taken for compliance of this court's order, to the extent that only 4 more petitioners are left to be satisfied. As satisfied, quite in keeping with the set order of this court. Therefore, this petition may be disposed of with direction to the respondent authorities to complete the process within expeditiously. Next, on consideration of the submission made, since it is clear that the respondent has expressed their intention to comply with the order in question, and till date, out of 92 original petitioners, only 4 of them are left to be paid as far as the dues are concerned. Therefore, the submission of the learned counsel for the petitioner is accepted. This petition is hereby closed. However, the respondent are directed to comply and to complete the process expeditiously, preferably within a period of 2 months. Be sure it's 2 months.
I don't have to
Your
come
Lordship,
again.
already there only 4 days.
For
They
4
will
people.
rectify. Only they have to rectify now. Further. Okay.
Preferably within a period of 2 months, as agreed to by Mr. Devnath, the CGC.
Obliged, Lordship. 1 and 2, 2 also.
2 also listen.
So in view of the order passed, this petition stands disposed of.
Obliged.
Item number 4.
May I please, Your Lordship? Your Lordship, I would seek some time, some more time, as the senior counsel is in hospital. Sir Yadav is in the hospital actually.
Who's the senior counsel?
Sir Yadav, Madam Yadav and Poonam Yadav and Saurav Yadav.
Both of them are in hospital?
Yes. Actually, the wife of Sir Yadav she's been admitted.
Okay.
And that's the reason they are both in the hospital itself. So just seeking some more time.
But why are you dealing this matter?
Spending quite some time.
Another date, on a short date.
To kikis to bayu ng afir kanu. To kanu 1 week, 2 weeks. 6, 7, 8.
was informed that in one of the cases the respondent has passed away, my lord.
I have passed. That I'll pass. But pass order.
Your Lordship, here actually we received a photocopy, but the original is there.
Just a moment. Let us finish discussion. We'll take up your matter. The learned counsel for the respondent has sought for accommodation on the ground that the conducting counsel is indisposed due to personal difficulties.
Well,
this will not be objected to by Dr. N. Musica, learned DSGI. Matters adjourned. This is same after 2 weeks.
Much a pleasure.
So this will cover 4, 5. 4.
Item number 5.
This is correct.
The petitioner, the respondent here is okay.
Yes,
Yes,
Your
ma'am.
Lordship.
So, same order.
Item number 6.
Here, my lord, the respondent has passed away. That's what the same.
Mr. Learned counsel for the respondent has submitted that the respondent is since deceased. However, it is prayed that the intimation of the death of the said respondent may be allowed to be filed by way of an affidavit to bring on record the death certificate, etc. As prayed for, that is allowed. This is matter of 2 weeks.
Item number 7.
So same order.
Item number 8.
Same order.
Obliged, Your Lordship.
This is also similar matter.
This is a different case altogether. Mr. Pandit is ready, so we'll take out the matter.
Well, actually, all these matters were listed together on last occasion. Mr. Joshi.
Yes.
Mr. Joshi raised the question of maintainability.
Maintainability.
And then I placed. I placed.
You are there, or Mr. Joshi is there in this case?
No, I'm for
Number 8, Mr. Pandit is there. 4, 5, 6, 7, Mr. Joshi is there.
Okay, that's a different thing.
Well,
But they are not connected to this. I think 4, 5, and 6 are connected to the same case.
Same case.
But here it's a different thing.
But in all the cases, we have come against grant of bail by the trial court.
That's true. But he has not raised the issue of maintainability.
Are you raising the issue of maintainability or not raising?
Why? Because that is settled law, Your Lordship, that under that provision only cancellation can be filed.
439(2).
Yes.
Yes.
There is no quarrel because there is no other provision by which the bail can be cancelled.
Yes, of course.
Except in a special act like UAPA. So I am not going on that.
Smell.
Yes.
But we have come against the order, my lord, passed by the learned special judge Shillong, my lord. Lordship will find that order at page 17, my lord.
Yes, Dr. Musica. First, before we proceed, what struck my mind is this: that since you have come against an order of bail passed by the trial court, is it not proper for you to approach the trial court first and get the bail cancelled?
But why we have come? We have come because under the provisions of CRPC, my lord, we can go to the same court only for cancellation of bail.
Yes, that's
cancellation of bail is only on certain conditions which are mentioned in the CRPC, the violation of bail conditions and other things, my lord. My lord, here we are not on violation of bail conditions, my lord. Here we are challenging the very propriety of granting a bail on the face of Section 37 of the NDPS Act when it involves commercial quantity, my lord. So it is in the nature of appeal against the correctness of the order, my lord, passed by the learned trial court.
That is where the issue of maintainability will come in.
My lord. That is where the,
under which provision you have approached this court?
Well, we have approached under 439(2), my lord, read with 482.
Read with 482.
My lord. In fact, on last occasion I placed several decisions, my lord. to substantiate, my lord, and there are direct decisions of the Supreme Court, my lord, on this. I've given a compilation. The other, go to item number 4, I think. Like this flagged ones. Yes. The first decision, my lord, is 2020 volume 18. There are 8 and 9, my lord.
First decision is
2020 volume 18 SCC 693, my lord. Bharat Bhai, Bhim Bhai.
para
8 and 9, my lord.
yes.
I'll read these two parameters. Though an application has been filed before the High Court under Section 439(2) CRPC, that is an application for cancellation of bail, by perusal of the grounds raised in the application, it is seen that the appellant has raised grounds challenging the exercise of discretion in granting bail to the respondent number 2 and 3 under Section 439 CRPC, and that the order granting bail is unsustainable in law. In effect, the application filed was only challenging the order of grant of bail on the ground that it was an arbitrary exercise of discretion. The court, while granting bail, should exercise its discretion in judicious manner by taking into consideration the relevant facts as held in State of UP versus Amarmani Tripathi. It is well settled that the consideration applicable for cancellation of bail and consideration for challenging the order of grant of bail on the ground of arbitrary exercise of discretion are different. While considering the application for cancellation of bail, the court ordinarily looks for some supervening circumstances like tampering of evidence either during investigation or during trial, threatening of witnesses, the accused is likely to abscond, and the trial of the case getting delayed on that count, etc. Whereas in order challenging the grant of bail on the ground that it has been granted illegally, the consideration is whether there was improper or arbitrary exercise of discretion in grant of bail. The appellant has challenged the very grant of bail on the ground of arbitrary exercise of discretion, ignoring the relevant materials to be considered in the application for bail. Since the High Court proceeded under the footing as if the appellant had filed an application only for cancellation of bail, for which the consideration is different, the impugned order is liable to be set aside and the matter is remitted to the High Court for consideration of the matter afresh. So, my lord, as I submitted, my lord, for cancellation of bail, considerations are different, my lord.
Yes.
And so we can come under 439(2), challenging the very propriety or exercise of the powers, exercise of the discretion, my lord. So that's the first decision, my lord. On the second decision, flag B, lordship will kindly see, my lord.
Yes.
This is 2008 volume 5 SCC, my lord.
Yes.
2008-5, 66, para 23, 24 and 25, my lord.
Yes.
Para 23, I'll read, my lord. Even though the reappreciation of evidence as done by the court granting bail is to be avoided, the court dealing with the application for cancellation of bail under 439(2) can consider whether irrelevant materials will be taken into consideration. That is so because it is not known as to what extent the relevant materials weighed with the court for accepting the prayer of bail. In Puran Rambilas, it was noted as follows. Further, it is to be kept in mind that concept of setting aside the unjustified, illegal or perverse order is totally different from the concept of cancelling the bail. on the ground that the accused has misconducted himself or because of some new facts requiring such cancellation. This position is made clear by the court in Gurcharan Singh State versus Delhi Administration. In that case, the court observed as under. If, however, a court of session had admitted an accused person to bail, the state has two options. It may move the session judge if certain new circumstances have arisen which were not earlier known to the state and necessarily, therefore, to that court, the state to that court. The state may as well approach the High Court, being the superior court under section 439(2), to commit the accused to custody. When, however, the state is agreed by the order of the session judge granting bail and there are no new circumstances that have cropped up, except those already existing, it is futile for the state to move the session judge again, and it is competent in law to move the High Court for cancellation of the bail. This position follows from the subordinate position of the Court of Session vis-a-vis High Court. The perversity as highlighted in Puran case can also flow from the fact that, as noted above, the irrelevant materials have been taken into consideration, adding vulnerability to the order granting bail. The irrelevant material should be of substantive nature and not of a trivial nature. So basically, my lord, Supreme Court reiterated the position, my lord, that we can approach in case of cancellation of bail, we have to go to the same court, my lord. But if we are challenging the very propriety of the order, we can come to the High Court, my lord. And then, my lord, flag C in similar lines, my lord.
This is the case referred to in the other case.
Yes, Puran, that was referred there, my lord. 2001 6 338.
Yes.
The relevant paragraph, my lord, 11, 13, 14, 16 and 17. 11, 13, 14, 16, 17. Para 11 and street.
Yes.
Further, it is to be kept in mind that the concept of setting aside the unjustified, illegal or perverse order is totally different from the concept of cancelling the bail on the ground that the accused has misconducted himself or because this was quoted, my lord, in the early edition, the same paragraph, my lord.
Yes.
Then, my lord, para 17, my lord, the findings, my lord.
Yes.
The question came up, my lord, whether it is an interlocutory order and 482 can be exercised or not. The Supreme Court answers, my lord, para 17. Further, even if it is an interlocutory order, the High Court's inherent jurisdiction under section 482 is not affected by the provision of section 397(3) of the Code of Criminal Procedure, that the High Court may refuse to exercise its jurisdiction under section 482 on the basis of self-imposed restriction is a different aspect. It cannot be denied that in securing the ends of justice, the High Court can interfere with an order which causes miscarriage of justice or is palpably illegal or is unjustified. My lord, next decision, flag A, is grant of bail in NDPS cases, my lord. This was an
E or
important.
D?
Nawaz Khan, my lord.
D?
Flag D, my lord. Round 21, volume 10 SCC, page 100, my lord. Para 20, 21, 25, 26 and 29, my lord.
Have you given copy of the citation to him? No.
Citation, I gave it to Mr. Joshi that time.
You should have given it to him, because these are points of law he has to refute.
He has to answer. But as far as maintainability, my friend was almost admitting that one.
That provision, I am aware, your lordship, regarding maintainability, because this state has optionless. Otherwise, they will be optionless only on the ground of violation. That is okay.
Decisions are settled.
Yes, that is settled.
As far as
maintainability is settled, because there is no otherwise state how they will be optionless. So regarding maintainability, that's why
in any case, you see, in all these matters, you see, finally parties have at best resorted to 482.
Yes.
That covers everything.
Everything, yes.
Everything.
Instead of 390.
Why I invoked 439 to read with 482, my lord, in my petition, because some decisions of Supreme Court But Supreme Court is Supreme Court. They can say give full
yes,
latitude.
there are
my
some
lord.
decisions which you say,
Which
they
refer to 439
tagged together and say
My
that,
lord.
you know.
That is for interlocutory order.
Well.
If there is interlocutory, but 482 covers everything. Your worship. They can come up with that 482. Now,
Not everything, of course.
yes.
It depends. Principles are there to set out, guidelines are there. How it is to be.
Then interlocutory order comes in the picture. My lord. If it is in interlocutory order, 482 cannot be invoked. So that's why to be
397 is there. Give him a copy of this.
well. I'll give citation will do.
Citation will do.
No copy. Citation.
It's quite bulky. Okay, I'll give copies. I'll give it today.
Are you done with you complete your submission?
Well.
He can reply today, or if he wants next day, it's up to him.
My lord,
go to the
just
facts.
I wanted to point out, Your Lordship, these 5 witnesses, in this case 5 witnesses has already been examined. Just for 3 witnesses left, Your Lordship, and these 3 witnesses since 2023 they are not bringing the witness. I am appearing, I am not violating any condition. So,
You see, Mr.
yes,
You can make out a case.
Yes.
Well, that is also one ground.
yes,
The ground is on the length of the proceedings.
yes,
That is also one thing to be considered. The court will
yes,
will look into the aspect of the matter. But we are now on another
yes, aspect.
another ground. See. So you wish to continue, or
Otherwise, Your Lordship, but because that other pending matters also, that will be covered up because everybody will make, yes.
that doesn't matter. It will be covered up.
Yes, yes.
Once one matter is
One,
decided,
yes,
I
yes,
think,
decided, then it will cover it. Yes.
except if some other lawyers are more brilliant than you, then
Yes.
that's it.
Only because Mr. Pandit is fair to my lord. Mr. Pandit is admitted. Mr. Joshi is not admitting, my lord.
Because I have
That's
gone
why
through
I
the
have to
judgment,
take
so
out all
many
the judgments,
judgments,
my lord.
and I am aware of that.
Whatever. As Dr. Musika said, see, right or wrong, Supreme Court is always right.
Yes.
So we have to bow down to that.
Then let it come on this day.
When?
Another day.
Come together, or you want to do separately?
I have no problem. Any manner it can come.
It would be better if perhaps this court hear all the petitions together.
Yes.
My lord.
Common order may be passed.
Yes. Only on the merit.
Because
it
one
will
thing
be-
I'll admit very frankly, my lord, this was filed in September, October 23, my lord.
True. That is why.
So to be fair to my friends also, my lord, maybe this has become like.
I've given you a hint.
My lord.
We have to look at the
My lord.
the proceedings.
Cancellation should have taken place immediately, my lord. Cancelling bail after 1.5 years, my lord. And there's nothing that they're avoiding trial or something. There's nothing like that.
That
But
is
because since it has been filed, my lord, it has to be, because I have no power to withdraw it. That's only difficulty.
like you said, maybe everything that will be done will be academic.
Yes.
Academically.
I heard Dr. N. Musika, at DSGI. The hearing is partly completed and will be concluded on the next date as prayed for. List this matter to 2 weeks.